for agency members. This is a very, very truncated version of the step-by-step procedure charts that appear in the existing what's legally required. So these are the kinds of questions that you should be asking yourself. And again, each of them could open up a whole world of conversation and questions. But let's just go over them really very, very quickly, because that's all the time we have left. So at the outset of any matter, does state law authorize the agency to make this type of decision? Just saying, make sure your regulations and your procedures are consistent with state law. If so, does state or federal law place any special limits on the scope of the agency's power? The Affordable Housing Act is a state law that places great limits on your ability. Basically, the Affordable Housing Act says whatever criteria you use to make a decision for planning and zoning, throw it out the window. It's state law that controls your criteria, and it's tipped very, very heavily toward approving affordable housing applications. And the constitutional provisions that I talked about, the right of private property, Fourth Amendment search and seizures, takings of property, those are federal limits that control what you can do, so you always have to be concerned about those. Then, will the decision require a hearing or notices to be given? If so, how, when, and to whom? Make sure you know what the state procedures are and how to meet them for giving notices and holding public hearings and when you have to hold public hearings. Does any member have a personal or financial interest in the decision? These are the ethical rules we were talking about. Could a member of the public reasonably believe that a member's personal or financial relationship to the matter or to any interested party would prevent the member from making an objective decision? It's the perception of the public that's critical. Does any member actually have any bias for or against any applicant or potential opponent? If you think, one of the applicants or opponents is a real jackass, you probably should step off for that particular proceeding. It's going to be hard for you to be objective. Has any member already decided how he or she will vote on the matter, even before hearing all of the presentations and testimony and reading all of the materials submitted in connection with the application? That's called predetermination or prejudgment. And if a court finds that you did this, your vote will be disqualified, and it may have an impact on the overall decision. Now, again, the courts have a very high standard, a high threshold for meeting this. If you say something like, I have real problems with this application, that's not enough. If you say, there's no way I'm going to approve this application, that's enough. So you have to be careful about making your decision in advance. And people do say things like that. I had one case where the chairman of the commission said about a person that I was representing at that point, oh, he's a crotchety, sullen old man and nobody believes anything he says. Decision overturned. And the funny thing is, that guy sat on the witness stand and he was so great, he was happy with himself. He thought and again, this is what I'm talking about. He thought it was perfectly fine for him to say that, and he was happy to admit it on the witness stand. He didn't understand that you can't do that. Has any member made statements that could lead a reasonable person to believe that the member cannot make an objective decision? Same kind of thing. That's what we're talking about. All right, during the hearing or formal presentation process, were any required notices given in the proper place and manner at the proper time? If you have a notice problem, if you find out that you made a mistake in publishing the notice, you published it too late or whatever, don't even bother going forward. Fix it, because if the notice was wrong, your decision is no good. It's just not going to be any good. You cannot fix it. You'd have to give a new notice and have a new hearing at the proper time, assuming you've got the timetable to do that. Do the applicable statutes and regulations for a particular matter require special notices to designated recipients, such as the Commissioner of Energy and Environmental Protection? There are a lot of types of applications that require notice to an abutting town, or the town clerk, or notice to a council of governments, or notice to a water company, or notice to the Commissioner of DEEP. So you've got to be aware of those applications that require that and make sure that those notices are given. What do the pertinent regulations say about this specific type of application or matter? What standards and criteria do they require the agency to use to make the decision? Follow the regulations. Don't go outside of the regulations. Don't create seat of the pants criteria. The last thing that I want to hear is a commission member saying, well, I don't care what the regulations say, I was appointed to do the right thing, and this is the right thing. That's going to get your decision overturned. Is that the right thing? I don't think so. I really need to get through this list right now. I will. Do state or federal laws such as the Affordable Housing Appeals Act, the Religious Land Use and Institutionalized Persons Act, that's a mouthful, but that's what it is, or the Americans with Disabilities Act require the agency to use special procedures or to consider different or additional standards and criteria? There are some state and federal laws that affect your regulations, and because state and federal law supersedes your local regulations, you can't do anything about it. So with the RLUIPA, the Religious Land Use Act, if somebody's coming in with a proposed religious use, you've got to consider the federal statute, the federal implications. If you're dealing with a religious use that's coming in, get advice from your attorney. That's all I can say. Don't play with that one. You've got to know how to handle those applications. Same is true with affordable housing. Same is true with ADA. ADA is actually not that hard to meet, but if somebody comes in with an ADA matter, you've got to know that you've got to provide reasonable accommodation for somebody with a disability. That can happen through the zoning commission, through the zoning enforcement officer, or through the ZBA. But you just got to know how to deal with that. Again, that supersedes your regulations. What evidence has been presented both for and against a particular decision? Are there any important issues that have not been discussed or facts that have not been presented on the record? Do the applicable statutes and regulations require the agency to make findings? Okay, they're all parts of the same thing. You've got to make your decision based on what has been presented in the public forum. If there's been a hearing, it should be everything that went up to the time of the close of the public hearing and nothing beyond that. If there hasn't been a public hearing, then it's whatever has been submitted to you in the course of your meetings. But the evidence that you're going to base your decision on has to be in the record. And again, if it was the applicant's burden to submit certain evidence and the applicant didn't do that, you can deny. Because the denial is based on the evidence. What it's based on is the lack of submission of required evidence in that case. It's always got to be evidentiary bound. Were all interested persons allowed a reasonable opportunity to participate in the process? Did the agency give everyone a reasonable opportunity to know about issues or concerns that could affect the agency's decision? Again, we could spend copious amounts of time on this, but when you're allowing people to speak, you have to be careful about how you do it. You can limit people's time at a public hearing, but you can't stop them from saying everything that they think is relevant just by setting an arbitrary deadline on it. Got to make sure everybody has the opportunity, and I can explain a procedure to do that. I don't have the time right now. Have there been any expert witnesses? We talked about that. Has the agency complied with freedom of information requirements? We generally talked about that. Required notices of the decision, were they given in the proper place and manner? If you don't do that right, your decision can go out the window. Who is authorized by law to enforce the regulations? We talked a bit about that. What limitations to state and federal law? We talked a little teeny bit about that. Again, that's that Fourth Amendment concern. What legal options are there for enforcement and which option is most appropriate? Again, that's a subject of its own time. So, we're getting right to 8:30. Did you have a question? You can get to me with 1 minute to go.
If in your requirements for a hearing, the applicant has to put a sign on their property.
Yes.
And they also request information on their sign. They give the wrong date for the hearing, give the wrong time, the wrong place.
Okay, question is, if the regulations require the applicant to post a sign on their property, and they post a sign but they give incorrect information about the date, time, or place of the hearing, what should the commission do? What I would suggest is that the commission, and this may sound harsh, what I would suggest is that the commission deny the application on the grounds that proper notice was not given and require the applicant to start over again. That's the safest course for you. Yes, sir.
Yes, our town's going through a current POCD to adopt in the next 10 years. And some of the recommendations require zoning amendments or regulations. What is, and planning and zoning are separate in our town. What are our obligations? Do we have to address them? Or can we just ignore them as far as their recommendations?
whether the zoning commission can ignore the POCD?
Correct.
The zoning commission legally is authorized to disagree with the POCD, but normally when it does that, in adopting its regulations, it has to explain why it's doing it. So it's possible that a failure to properly explain why you're not doing something in accordance with the POCD might cause a change to be overruled by a court, although that would be unusual.
Can somebody come into town and read, get a copy of our POCD and force us to bring, say, going from 3 acres to 1 acre, we say, no, we're not gonna do it. Somebody comes in and says, it's in your POCD, you have to go to 1 acre. Do we have to?
No. How's that? It is, it's 8:30 if it's quick.
As a zoning officer, and you get a complaint and you clearly see a violation from the road, are you allowed to go on the property to get more information?
No,
Okay.
no, not without consent from the landowner or an order from the court.
Can you use police?
What's that?
Can you use police department?
They also have to have probable cause. So you don't have the authority to go on the property without the consent of the landowner. If the landowner refuses, get a warrant. You now have probable cause.
Thank you all for standing up of legal basics tonight. We are having another training from Bruce Hyde of the Land Use Academy in March. So if you know you want to come to that tonight, let us know and we'll sign you up. And we'll see you in March. And otherwise, we hope to see you at a future Fifth Thursday Forum. And thanks again to Mike.